Hello and welcome to this video where we'll be breaking down one of the most important steps in a Texas divorce, the discovery process. As a divorce lawyer, it's my job to help clients understand what happens during this phase and how it can affect the outcome of your case. Whether you're the one filing for divorce or responding to a petition, understanding the discovery process can give you a significant advantage. Before we get started, a quick disclaimer. The information in this video is intended for educational and general in nature. It does not constitute legal advice for your specific situation. If you're going through a divorce or have legal questions, I encourage you to consult with a qualified attorney to get personalized advice tailored to your case. Now let's dive in. What is the discovery process in a Texas divorce? The discovery process is one of the most critical phases of any divorce case. In Texas, the discovery process allows both parties to gather evidence, facts, and information that will help build their case. This evidence is crucial for issues like property division, alimony, child custody, and child support. Think of discovery as an exchange of information between both sides. Each party must provide the other with relevant details and documentation. This is the opportunity to gather all the facts, ensuring that no one is hiding anything that could affect the divorce settlement or the court's decision. Discovery can sometimes be a lengthy process, and in contentious divorce cases, it can become a battleground field. But understanding the tools and strategies involved will help you navigate this stage with confidence. Discovery tools in a Texas divorce. In Texas, there are several methods or tools available to collect evidence during discovery. Let's explore the most common ones. Interrogatories. Interrogatories are written questions that one party sends to the other, requiring written answers under oath. These questions can cover a wide range of topics, including finances, property ownership, and child custody arrangements. The party receiving the interrogatories must respond within a set time frame, usually 30 days, and the answers must be truthful, as they are signed under oath. Examples of questions you might find in an interrogatory could include, what is the total value of your property? Are you employed? And if so, what is your income? Do you own any businesses or have investments? What are the names, ages, and addresses of any children involved in the case? These questions allow each side to gather detailed information about the other party's circumstances and assets. Requests for production of documents. This tool allows one party to request specific documents from the other side. The documents can include financial records, tax returns, property deeds, bank statements, and any other records that are relevant to the divorce. Common documents requested might include tax returns for the last 3 years, pay stubs and proof of income, bank account statements, mortgage documents and property deeds, retirement account statements. The goal of these requests is to obtain clear, concrete evidence of a party's financial situation, assets, and debts. These documents can play a significant role in determining how property should be divided or whether spousal support is appropriate. Depositions. Depositions are in-person interviews conducted under oath where one party or their attorney questions the other party or witnesses. A court reporter records everything that is said during the deposition, which can later be used in court. Depositions are useful because they give attorneys the chance to assess how the other side will testify in court. They also allow attorneys to probe deeper into testimony and ask follow-up questions. Common participants in depositions include the parties themselves, which are you or your spouse, witnesses to the marriage or your living situation, experts like financial analysts or psychologists. Depositions are typically conducted in a lawyer's office or a neutral location. They can be intense, but they are essential for building a strong case. The next form of discovery are requests for admissions. A request for admission is a formal request in which one party asks the other to admit or deny certain facts. Now, this tool helps narrow down the issues in the case, as it forces the opposing party to either confirm or deny specific details under oath. Here are some examples of some requests for admissions. Admit that you have been living at the address listed in the divorce petition. Admit that your income is $100,000 per year. Admit that you were married on a certain date. If the opposing party admits to something in a request for admission, it can simplify the trial process as it confirms certain facts that no longer need to be disputed. Subpoenas. Subpoenas are formal requests that require third parties like banks, employers, or financial institutions to produce documents or to testify in a case. They can be used to obtain information from sources that are not directly involved in the divorce, but may have important information. For example, a subpoena could be used to obtain employment records from an employer, bank statements from a financial institution, or expert testimony from a financial planner or a forensic accountant. Now, subpoenas are powerful tools for obtaining critical evidence, especially when one party is attempting to hide assets or manipulate financial records. Gathering evidence for your case. Gathering evidence during the discovery process is one of the most important aspects of your divorce case. The evidence you collect will ultimately help you with the following: show your spouse's financial situation, demonstrate the value of marital property, prove your case for child custody or child support, and support your claims for spousal support. Here are some tips for effectively gathering evidence. Number 1, keep records organized. As you receive responses to interrogatories, production requests, and other discovery tools, make sure to organize everything carefully. Maintain a file for each piece of evidence you receive, and be sure to note the date it was received. This organization will help ensure that you're ready when the time comes to present your case. Work with professionals. In some cases, especially when dealing with complex financial matters, you may want to work with professionals like forensic accountants, real estate appraisers, or child psychologists. These experts can help gather and analyze evidence that will support your claims in your divorce case. For example, a forensic accountant can help uncover hidden assets or debts, while a child psychologist might assess the best living arrangements for children involved in the case. Stay honest and transparent. While it's tempting to hide assets or manipulate documents during a divorce, doing so can have legal consequences. If you're caught hiding assets or lying about important financial information, the court could penalize you, and it may negatively affect the outcome of your case. Be upfront and honest about everything, even if some of the evidence is difficult. The truth will serve you better in the long run. Handling disputes during discovery. In contentious divorces, disputes can arise during the discovery process. Perhaps one party is refusing to cooperate, or they are being less than forthcoming with requested documents. Here's how to handle common discovery disputes. Number 1, non-compliance with requests. If one party fails to respond to discovery requests, the other party can file a motion to compel with the court. This motion asks the judge to order the non-compliant party to provide the requested information. If the judge grants the motion to compel and the other party still refuses to comply, they could be penalized, including facing fines or sanctions. Number 2, objections to discovery requests. It's not uncommon for one party to object to certain discovery requests, claiming that the request is overly broad, irrelevant, or too intrusive. In these situations, your attorney will review the objection and decide whether it's legitimate. If the objection is without merit, the attorney may file a motion to compel the requested information. Number 3, mediation or settlement negotiations. If disputes over discovery become too contentious, parties may turn to mediation or settlement negotiations to resolve the issues without the need for further court involvement. Now, mediation can help both parties come to an agreement on what information should be shared and how to move forward with the case. Importance of discovery in a Texas divorce. While discovery can be an intimidating and sometimes contentious part of the divorce process, it is also incredibly important. The information you collect can directly influence your case's outcome, particularly when it comes to crucial issues like property division, alimony, child custody, and child support. When both parties exchange information during discovery, they are essentially laying the foundation for how the divorce will proceed. Whether you're seeking a fair property division or trying to secure a reasonable child custody arrangement, discovery can ensure that both sides are working from the same set of facts. Let's break down how discovery impacts each of these critical aspects of your divorce. Now let's start with property division. Texas is a community property state, which means that any property acquired during the marriage is generally considered to belong equally to both spouses, unless there is a prenuptial or postnuptial agreement that states otherwise. During the discovery process, the parties will exchange financial information that reveals the full extent of their assets and debts. Some key elements you'll want to focus on during the discovery include real estate. A clear understanding of the value of all real estate, whether it's the marital home or other properties, is crucial. You may need an appraisal to determine the value. Retirement accounts and pensions. These can be some of the most valuable assets in a divorce. Make sure that you request records for any retirement accounts or pension plans, including 401ks, IRAs, and any other employee benefits. Investments and business interests. If your spouse owns a business or has investment accounts, it is important to gather the relevant financial documents to determine their value. Debt. Don't forget about debt. Whether it's credit card debt, mortgages, or personal loans, all debts should be accounted for during discovery to determine how they will be divided. Having accurate and comprehensive financial records during the discovery process will help ensure that the division of property is fair and equitable. Without this, it could be difficult to establish an accurate value of assets, and you may end up losing out on something that you're entitled to. Alimony or spousal support. In Texas, spousal support, often referred to as alimony, is not automatically awarded in every divorce. However, it may be granted under specific circumstances, such as when one spouse cannot meet their basic needs due to a lack of income, or when the marriage lasted a long time. During discovery, both parties will disclose financial information including income, expenses, and assets. This helps the court determine whether spousal support is appropriate. When requesting discovery, you should ensure that you obtain proof of income. This includes pay stubs, tax returns, and any other documentation that shows how much your spouse earns. Living expenses. This includes details on your spouse's monthly living expenses and lifestyle. You'll want to present an accurate picture of your spouse's financial needs and ability to pay support. Property ownership. The value of marital property can also influence the decision on spousal support. A spouse who stands to receive a large portion of the marital estate may be less likely to qualify for support. If you are seeking spousal support, the discovery process can be vital in proving that your spouse has the ability to pay and that you need the support. And likewise, if you're the one being asked to pay spousal support, discovery can help you show that it's unnecessary based on your financial situation. Child custody and child support. When it comes to children, the discovery process becomes even more crucial. The primary concern in Texas divorce cases involving children is the best interest of the child, and discovery allows both parties to gather evidence to support their desired custody arrangement. Here are some specific areas that may be relevant during discovery. Parenting and communication. You may want to gather evidence about your spouse's relationship with the children, including how often they see them, how they communicate, and whether there are any concerns about their ability to care for the children. Work schedules. A party's work schedule can be crucial in determining custody arrangements. For example, a parent who works long hours or travels frequently may not be able to spend as much time with the children, which could influence custody decisions. Financial stability. Child support is often based on the income of both parents. During discovery, both parties will provide information on their incomes and financial resources, which the court will use to determine the appropriate amount of child support. And finally, your child's needs. Discovery may also include medical and educational records for the children, which can help establish what their needs are and what arrangements would best serve them. Through discovery, you can gather critical evidence that supports your position on child custody and child support. Whether you're seeking primary custody or a fair visitation arrangement, gathering evidence on your child's well-being and both the parent's ability to care for them is key. Discovery strategies and tips for success. While the discovery process can sometimes feel like a battle, there are strategies you can employ to maximize your success and ensure that you get the information you need. Be proactive. One of the best strategies in discovery is to be proactive. Don't wait until you're in the middle of your case to start gathering evidence. The sooner you can begin requesting documents and information, the more prepared you'll be for negotiations or trial. You should start by identifying what documents and information are critical to your case. This might include financial records, evidence of misconduct, or information regarding child custody arrangements. By getting a jump start, you'll be in a stronger position when it's time to move forward. Understand the rules and timelines. Each discovery request in Texas has specific rules and deadlines. For example, you must respond to interrogatories and requests for production within 30 days, unless otherwise agreed upon. If you don't comply with these deadlines, you could face sanctions and penalties. Make sure you understand the rules governing discovery and keep track of all deadlines. You can ask your attorney to help you manage the process so that you're not scrambling at the last minute. Be thorough, but don't overwhelm. While it's important to be thorough during discovery, you also don't want to overwhelm the other party with excessive or irrelevant requests. If you overburden the other side with an excessive number of questions or requests, you may prompt delays or objections. Your goal should be to ask focused, well-planned questions that are directly related to the issues in your case. For example, if you're fighting for custody, request documents or testimony related to your spouse's relationship with the children and their ability to care for them. Anticipate objections. Expect that the other party may object to some of your discovery requests. These objections could include claims that the request is too broad, that it is not relevant to the case, or that it violates privacy rights. Your attorney will be able to help you respond to objections and, if necessary, file a motion to compel the other party to comply. Evaluate the evidence carefully. Once you begin receiving responses and documents from the other side, it's crucial to evaluate the evidence correctly. Does the information align with what you expected? Is there something missing or inconsistent? If you notice any discrepancies or suspicious behavior, such as missing bank statements or incomplete financial records, be sure to address it. You may need to take further steps, such as issuing subpoenas or requesting additional documents. The discovery process is an essential part of the Texas divorce process, and it plays a significant role in determining how your case will unfold. From gathering financial documents to questioning witnesses and requesting information, discovery provides both parties with the tools they need to gather facts, clarify issues, and build the case. Though it can be time-consuming and sometimes contentious, discovery is an opportunity to ensure that your divorce is based on a full and accurate understanding of the facts. Whether you're negotiating a property division, seeking custody of your children, or asking for spousal support, discovery will provide the foundation for your legal strategy. So make sure you're prepared. Work with your attorney, stay organized, and always be honest in the process. If you're in the midst of a divorce, don't hesitate to reach out to a qualified lawyer to help you navigate the discovery process and to protect your interests. If you found this video helpful, please be sure to like, share, and subscribe for more videos on divorce and family law. And as always, if you have any questions, leave them in the comments below. Thank you for watching and good luck.